It is the summertime right now in Texas, and we always get a lot of emails, a lot of questions from people about renting, about what their landlord's doing to them or what they're allowed or can or cannot do. And so we invited Ryan Marquez here. You're with the University of Houston Law Center, director of the Civil Justice Clinic. Thanks so much for joining us, Ryan Marquez.
Thank you for having me, Amy.
Yeah, so okay, let's jump right in. You said, oh gosh, I mean, some of the most common things that renters are asking about right now. Let's talk about air conditioners. I mean, if you're in an apartment or even if you're in a rental house and your AC goes out, what has to happen? I mean, how long does a landlord have to fix that problem? Because it is hot right now.
Well, the landlord, they only have to fix things that affect the health and safety of an ordinary tenant. And here, when we're talking about these type of temperatures, for my opinion, I believe that would qualify as something that affects the health and safety. And then the landlord, they get what's a reasonable time to make a diligent effort to repair. Under the statute, 7 days is considered reasonable under most circumstances, unless it's something that's really an emergency, like some sewer coming up. And here, temperatures, they could fall closer into maybe a closer timeline than even the 7 days. But unfortunately, there's no specific date. But one thing to note is the timeline doesn't even begin until the tenant sends a written notice saying that there's this condition that materially affects their safety of that or any of the occupants.
So a phone call doesn't cut it. At the same time that you may place a phone call to your apartment complex office, you also need to be putting something in writing and saving that, right?
A phone call does not cut it in any way, shape, or form. In fact, you really do want to put it in writing, and you want to send it like certified mail, return receipt requested, as an addition to email. The more ways you send it, the better. But you want that delivery method to be trackable, because under the statute, if you send it in a method that can be tracked, such as certified mail and the return receipt, then you only have to send one notice. If you don't, then you're going to have to send a follow-up notice after the time period.
You don't realize that this is going to be a problem if you're a renter until the fourth day that you're sitting there. You had called and they said they were sending someone and then they don't. And you're like, oh, great. So, I mean, again, the countdown from when they're required to fix it hasn't even started, because according to the statute, you haven't made an actual request in writing.
Correct, right. And that's what a lot of people don't realize. And they usually will do one or two follow-ups just orally. And they might do even, sometimes they might do what's called a work order request, and they might fill that out. But that probably doesn't count under most circumstances either under the statute. And sometimes in the leases, they'll specifically state work orders do not qualify as a repair request under the statute.
If after you're listening to this, you want to go back and look it up, one thing that I guess people should realize is it doesn't specifically say anything about air conditioning. It doesn't specifically say anything about each individual repair item. It's just sort of, if any of these repairs in your apartment represent a health and safety issue, then it could fall under this code of
Right. None of them specifically mention any repairs whatsoever.
So what statute are we talking about, Ryan?
It's going to start on 92.052, as well as, yeah, that's going to be the statute that you're going to want to look for, 92.052. And one place people can go that sometimes have examples of repair letters is texaslawhelp.org. And that can have the statute as well as samples of what the letter should look like to request a repair to the landlord.
Oh, cool. Almost like a template. So say I have this problem.
Correct.
It seems overwhelming to sit down and figure out what this letter should say. You could go to texaslawhelp.org, get this template, sort of fill it out and send it in, maybe the same time that you make that request. Because we know if it's 102 and it feels like 113 inside your apartment, you're going to call. But at the same time, let's go ahead and write this letter and send it off.
Correct. And for most people, it'll be worth the $6 or $7 it costs to send it by certified mail, because at least then they start the timeline and they can request additional remedies later on.
Yeah, so I hear a lot of what you're saying, that maybe that would count. Maybe, you think air conditionings would, I mean, so who in the end makes the ultimate decision on whether this was a health and safety issue, on whether the landlord moved fast enough? Who makes that decision?
Ultimately, it will be a judge that makes that decision if they go to the Justice of the Peace Court. Usually, it's going to be the Justice of the Peace for most of these situations.
Yeah, I mean, and so that's what people, when we're hearing from renters, they're like, can you make them do this? The only person or authority to make them do anything is a judge enforcing the statute, right?
That is correct. The judge can order them to make any of the repairs affecting the health and safety as long as it falls under $20,000 worth of repair cost. If not, it has to go to a higher court.
Okay, we won't spend a whole lot of time talking about it, but let's talk a little bit about Justice of the Peace Courts, also known as small claim courts. A lot of people feel like, oh, I've got to get an attorney, I have to hire an attorney, but that's not what you're supposed to do in small claims court. You're supposed to be able to go in there by yourself, right?
That is correct. You are supposed to be able to just go and represent yourself, but you still have to follow all the steps that will entitle you to any of the relief you're requesting. Here, you're requesting repair remedies, which means you have to track the statute and make sure you send those repair notices. And one thing that a lot of people get wrong here is you have to be current in rent when you send that notice. And sometimes by the time they come to us as attorneys, they usually have gotten so frustrated. You don't usually seek out an attorney if you're just a little upset. Mm-hmm. Usually you seek out an attorney when you're really upset. And by this time, they feel like the landlord is not fulfilling their obligations, so they don't pay their rent. And unfortunately, that is one of the worst things you can do, because as soon as you don't pay your rent, not only are you subject to an eviction, but you also cannot demand any repairs anymore because the statute requires you to be current in your rent.
Wow. I mean, the laws in Texas really are stacked in favor of landlords, right?
From my viewpoint, yes. I don't know that a landlord attorney that represents landlords would state that, but from my viewpoint, I think they favor landlords.
Yeah. So let's talk a little bit about some of those things. So say your AC is working fine, but can a landlord shut off your water or your power or just your AC? If for example, they're upset with you or you're behind on your rent. I mean, is that something legally that they can just go in and do?
Not if you're only behind in your rent. They cannot they're not supposed to exclude you from the premises, and that also includes removing appliances from the premises. To me, I would take it as, like, sometimes instead of removing the AC, because they're not going to usually do that, they have done things such as disconnect certain wiring in the AC to make it not function. To me, that's the equivalent of removing an appliance. And they're not supposed to do that except by the provisions of the code. And the code does not provide them to do that for being behind in rent. Now, if the landlord is supplying utilities and sends a separate utility bill or sends a utility bill and you're behind in that, they may, if they give proper notices, be able to disconnect it the same as any other utility company. But they do have certain notices that they have to send, but not for being behind in rent. They're just not allowed to do that.
Okay, yeah. And so what happens? What do I do if that does happen? If I'm in my apartment, maybe I'm $100 behind, $200 behind, and then I come home from work one day and I have no AC. What is my first step? What do I do?
Well, I guess first, you would have to, because who knows, sometimes ACs do go out, but if you know it's because your landlord did it, the first thing you're going to want to do is email them and send them a letter saying that you want them to repair it. But because this is such a quick process, you're kind of gotten something taken from you, you could go file a writ of restoration or reentry in the Justice of the Peace Court. And that they can order them to reconnect the AC or, to me, restore that appliance to you, right? Because they've taken away the appliance, and the Justice of the Peace Court can do that.
Well, how much does that cost me to do that, to file that writ?
Ooh, I'd have to check the cost of the Justice of the Peace, but some people, they qualify for what's called a statement of inability to pay, which means that they can actually do it for free if they come with under certain guidelines or get government benefits. Other than that, most Justice of the Peace cases cost about $130, I think is the going rate for some of them. But I have to check if this is one of the ones that are exempt.
Prices for everything is up right now. So, I mean, obviously rents are going up. And we've heard from some people who are like, oh my gosh, is it fair? I mean, can my landlord really raise my rent all of a sudden by $300 or $400 in 1 month? The answer is
The answer is if your lease is expired, then they can give you a 30-day notice to raise your rental amount. But if you're locked into a lease, they cannot raise the rent during the time of that written lease. Sometimes leases are for 6 months, 1 year, every once in a while, very rarely, 2 years. But during that time frame, they cannot. But once that lease expires, as long as they give you a 30-day notice, then they can increase the rent. And in Texas, we don't have any kind of limits to what they can increase the rent to.
I know that people don't want to hear that, but when one person who emailed and was asking that question or saying that it was so unfair, it was because her small, like 8-unit apartment complex was sold to a new owner. And she said, we knew that the rents were going to go up somewhat because they were making some improvements, but not, I think it was 800 something before. And then they're saying now it's going to be 1,200 something. The other thing that I think renters have to think about, which you don't want to, and you're just like, I have this much money to pay, is that the taxes have gone up on the landlords. They're now owing more taxes. It's costing them more money to make improvements. So you have to figure that that amount is going to get passed down to the renters, right?
Yeah, it's hit the economy and the inflation. I think it's hit everybody hard. I will say the only limits for rental increases is they can't discriminate though when they're doing rental increases. If they discriminate based on race or religion or any of those protected classes under the federal government, they can't increase on some people, but not others based on any of those protected classes. So that would be the only kind of restriction, is if they're being treated differently.
How do I know what they're charging my neighbor?
That is one of the big problems with proving any type of discrimination. Is it does require you to have that knowledge to know, oh, well, for example, all the Hispanic families are getting charged less than all the white families. That you will not know that unless you do find that information out. And how do you get it? Some people, if their neighbors share with them, but most people, they don't talk about those type of things on what they're getting charged.
We've heard forever about apartment complexes making deals with certain, a cable company, because the cable company has to come in and put the wire the whole complex to get people set up. So when you move into an apartment complex, they may say, hey, our cable provider here is Comcast or Xfinity, and that you don't necessarily have the choice. I mean, you're supposed to have the choice, but AT&T is not going to come in if they haven't wired the entire unit, correct?
That is correct. But there seems like there is some movement on this. Like I actually was looking this up in preparation for us, and it looks like for internet service providers, there might be, because they're a common carrier and they're subject to the FCC, and the FCC has just issued new rules that I think went into effect at the end of April of this year, that might start prohibiting for internet contracts that type of arrangement, to where it's an exclusivity thing. But that, before we know the final answer on that, it's going to have to take some time to see if anyone challenges that rule and how effective or broad that rule is going to be.
Got it. The person who specifically emailed me was in their new lease, it was a cable subscription was included, and it increased the cost of their cable from $30 to $89. And they're like, I can't afford that. So, I mean, what rights does the tenant have to say, okay, then I want the apartment, but I don't want this cable plan?
Well, see, and that's right now, like if this rule is put into effect, that could affect that, because the tenant should be able to, if it's an internet, especially internet service provider, should be able to choose. But traditionally, the companies have been allowed to do that, and the tenant's option, unfortunately, would be not to rent there. Would be kind of what the option of choice is, what the traditional notion of contracting is. But as we see, most of the times when there's that extra bargaining power, the power of choice diminishes for the tenants.
Yeah, and I mean, you know what I mean, obviously it's so unfair, but what I always feel like when people call me and say, usually too, they're at their wits' end. They've tried things. They think, okay, this landlord's trying to kick me out or force me out. We had one person call when the landlord removed the door off of their apartment, like in the summertime. So they come home from work and the door is gone. And so I'm like, I can call your landlord. I can go and put a camera in their face, but what happens the day after I leave? What happens the day after you get a judge to sign off on this or that? I mean, a landlord can make it very uncomfortable for you to live there, whether it's legal or not. I mean,
Yeah, there are some retaliation provisions that try to prevent being evicted or having a lease canceled after you take some type of legal remedies. But if we're just talking in reality, the relationship is gone. It's almost like a breakup of a personal relationship between you and your landlord is gone. And like you said, normally the landlord then is going to want you out, and eventually that is probably going to happen if we're going to be just practical about it. After the 6 months, the landlord will just not renew your lease, and you'll probably have to find somewhere else to go.
all right, let's talk about when people move out of apartments. This is really common. Even if they didn't have any problems and they go to move out, a lot of times, if it's a large apartment complex, there may not be anybody there on the day of your move out to do this walkthrough. But you've left what may be a fairly large security deposit that you're supposed to get back. There's rules on how long the landlord has to return that to you. Can you talk about that a little bit?
Yes, they're supposed to return that security deposit to you within 30 days of you giving them your forwarding address in writing and moving out and moved out. You can't have you have to move out. And then within that time frame, they're supposed to return your security deposit to you.
I have had instances in that case where they didn't return the security deposit, and it was helpful for the tenant to send a letter to the landlord and CC the Texas Attorney General's office, or to file a complaint with the Texas Attorney General's office, and it seemed to work to get them to go ahead and move a little quicker to get that deposit back to the former tenant.
Yes, no matter what, even if you don't copy anyone else on it, you should always send a follow-up letter. It will also help you in the event that the landlord does not return your security deposit, because they will be considered probably to be acting in what's called bad faith. And you could even recover then up to 3 times the amount of the security deposit that has been withheld from you.
Ooh, tell me about that. So basically, say I had a $600 security deposit at an apartment complex, in an apartment. I move out. First, let's just say the landlord does return my money, but just returns 300 of it. Can they do that?
Now, depending, see what happens with security deposits is really to protect yourself. The time frame that you should be protecting yourself is when you move in. I always recommend, because landlords will try to deduct any type of repairs that are necessary, but they can't reduce your security deposit for anything that is normal wear and tear. That is not allowed. But sometimes landlords will put extra charges there. So really, when you move in, you should take careful pictures and video of everything. Pictures, because sometimes people move too fast with a video that you really can't see anything, but detailed pictures of anything that is wrong with it. And you're supposed to do the same thing when you move out. Take very detailed, because that way you can show that the apartment didn't change. And so here, if the landlord wrongfully withheld that $300, because let's just say they were deducting for things that did not qualify, and you send this follow-up letter, that really puts them on notice that they may have be acting in bad faith. And so then in that circumstance, when you file your lawsuit in the Justice of the Peace Court to recover, like for that example, they could get possibly $900 back if the Justice of the Peace agrees they have acted in bad faith.
Okay. That's good information. Again, it's a consumer going to Justice of the Peace Court to try to get them to enforce these rules. Let's talk about mold. I hear from consumers all the time. Maybe there was a leak in the apartment that they say the landlord took too long to get to, or nobody realized there was a leak until they see mold. Common areas, bathroom, kitchen, but they see it maybe inside an air duct, coming down a wall. Are there any statutes that speak specifically to mold and mold removal and what they have to do to clean it up?
I would say nothing that's specific enough to really help tenants. It kind of falls within this health and safety of an ordinary tenant. Same with the repair statute, except that if there does need to be mold removal, like to where there needs to be remediation, then that person is supposed to be licensed to do remediation, kind of like an electrician or a plumber. But other than that, normally it's just the standard repair statute, unfortunately.
Yeah. All right. Hey, Ryan, I know you gave a lot of good information today for people who are renting. I appreciate your help. Is there any last parting words, thoughts that you thought you wanted people to know for sure? Most important thing to keep in mind?
Always pay your rent, and always any communication or sub agreements or anything with your landlord, put it in a written format. We have cell phones, take pictures, keep yourself evidence in case you do have to go to court. Hopefully things resolve where you don't need to go to court, but if you do, you're going to need that evidence to convince a JP court judge. So make sure you look after yourself, because you're in the end, the only one who can look after yourself is you.
All right. Thank you so much. Have a great day.
Thank you, Amy.